Assalamu alaikum, good evening viewers. Welcome to another edition of Legal Ease, where we try to make the law easy for you. We've had quite a long break since the last show. We're in the new year, and the topic today is going to be law in general. We're going to focus on contracts, we're going to focus on commercial law, but if you have any questions on any other issue related to law, you're welcome to call in. My guest this evening is Mr. Ghulam Amir. He's an advocate. He has over 16 years of experience, and although he's stationed in Johannesburg, he obviously operates throughout the country. And I know the other day he even went to Mauritius, so he operates as far as Mauritius and other parts of Africa. So he has certainly wide experience. Ghulam, welcome to the show, and Jazakallah for making your time available for channel radio, for ITV, for ITV, for Legal Ease.
Professor, Jazakallah khairan, assalamu alaikum to the listeners and the viewers. Thank you very much for that introduction. We kept the topic, as you say quite correctly, as wide as possible so that we can be of assistance if there are any questions to the listenership and to the readership, to the viewership. As best as we can, we will assist.
Okay, let's kick off. I've got a few questions, and some people have sent me some questions as well. They said, please, if you have a guest on and you're going to cover the topic, please, these are some of the issues we want you to talk about. So let's talk about the first one. The first one relates to, a contract or an agreement. The person entered into agreement with somebody else, and I've got it written down. It says, relates to duty to account. There's sort of partners, two people get into an agreement, they own property together, they own a business together, there's sort of profits obviously. What are their rights, what are their obligations, what are their duties towards each other, what can they take out of the business, how should they go about organizing?
I think the primary issue that would be of concern in a situation like that is a duty to account, as you point out. Now, if two people are in a partnership in a business, whether it's a restaurant, whether it's any kind of business, even a property owning company, which is a business, who collects rental, or a garden service business, something as small as that, any kind of business where there's a joint venture between two or more people, there immediately arises a duty to account.
Right.
It's a very, very fundamental and important aspect of our law. Because in businesses, generally, you'll get one person that's involved and in charge of the finances. He's the financial manager. And then you'll get often people that are in charge of the operations. And everyone has a different skill, admin sections. But often you'll find them all working together in a partnership. Now, more often than not, what we have is, we have a situation, in practice generally, you'll have people who are in the admin section or in the operations section who are kept in the dark, as it were, in relation to the income, the profitability, the expenses. And what normally happens is there's a dispute that arises. And the person who's kept in the dark generally says, well, there's probably more profits, I'm working so hard and I'm not seeing the income. Now, that usually, if not resolved initially, leads to a dispute, as you can imagine. So to avoid that, you must ask for an accounting. Now, there's a duty to account by the person who's in charge of the finances.
Okay, and this is a legal duty. Obviously.
It's a legal obligation, it's a duty, and it's a corresponding legal right by the person who doesn't have access to the funds, for example, the operations person. And generally what you would do is, the person who's in charge of the finance has to make available the books with the full proof, the vouchers, the underlying documents, etc. And if the person who receives that accounting is not happy with it, they can then challenge that and ask for further questions, and it's called a debatement. So it's a cause of action called an action of accounting and a debatement of an accounting. That's usually the cause of action. And if a person who's in charge of the accounts and the finances doesn't give you the records, it's a simple question of going to a court and getting an order asking for the accounting. And that way there's no dispute. But of course in businesses, we always say, in order to avoid that kind of difficulty, always make sure that when you enter into a partnership agreement, make sure that it's in writing, first of all, and make sure that these clauses particularly one relating to the accounting, is of course entrenched in writing so that there's no disputes. And of course the duty to account comes in as a result of what they call a fiduciary duty. It's a duty of trust. When you have a partner, there's a duty of trust, and therefore the duty of accounting comes in.
Okay, you mentioned something important. Obviously there's an obligation. Very often small businesses get into these things, two partners, two friends, two brothers. They get into this and they say, you know, let's start this little business, or we offer a little gardening service, or whatever the case may be, or a small business. But you said something really important. You mentioned something about it's a good idea to have it in writing. Now, that obviously talks about contracts then.
Yes.
Because an agreement is a contract.
Yes.
Does it have to be in writing, legally?
All right.
Obviously, it makes more sense if it's in writing, because one day when there's a dispute, you can look at what the contract says.
Yes.
But let's talk a bit about that,
Yes.
putting it in writing.
There's two sections to the question. The first one is, even if you don't have the duty to account stipulated or legislated in a contract and signed, or even in an agreement, an oral agreement, if you don't have that, the law still automatically gives you an entitlement or the right to an accounting. So it's independent of there being a contract. It's always nice to have a contract because it's stipulated, it clears the process and the procedure in relation to the accounting. But if it's not there, you'll have the right anyway. Now, that's the first part of the question you asked. The second part, of course, is whether a document, an agreement has to be in writing or not. Now, that's a bit of an important question, because I found from experience, generally people find, they say, well, you haven't got anything in writing, so there's no agreement.
Yeah.
Now, that's not correct. That's the furthermost from the truth. In fact, an agreement, if it's an oral agreement, so you say something, somebody accepts orally without any writing, is a valid and binding contract.
Right.
There are certain exceptions to the rule, of course. There are certain agreements which, even if agreed to orally, are not binding according to South African law. And one such example that comes to mind immediately is a formality of writing imposed on the sale of land. So if you sell your house to somebody orally, say a house for R1 million, it's an unenforceable contract, even though it's agreed to in writing. Very different from a Sharia perspective, of course. Yeah. If you sell your house for R1 million and it's oral, not in writing, Section 2(1) of the Alienation of Land Act says it's unenforceable.
Okay.
So except for those circumstances where the law, in fact, stipulates a formality, contracts are valid if they are oral. So if you say to somebody, for example, I'm going to sell my car to you at 100,000 rand, and the person says, yes, I accept. It's a valid and binding contract, and you're obliged to sell it. If you don't, you're in breach, and there are consequences that flow from there. So yes, the contracts are valid if they're not in writing, but except for the formalities that I've told you about. There's another important aspect about having written contracts. It's called the parallel evidence rule. Once something is in writing, it is an important aspect of the proof if there's a dispute. Now, the parallel evidence rule says that if something is in writing, for example, I'm selling this car to you at 100,000 rand and you will collect it next week, Wednesday. Yeah. That's a term of the contract. You can't lead evidence, or you can't say something contrary to that. It's inadmissible. So you can't say, well, even though the contract says I'll collect it on Wednesday next week. We agreed that
off the record.
Off the record. Yeah. It's inadmissible. It's called the parallel evidence or the integration rule. Yeah. And the importance of that is that it creates certainty in contracts, and the purpose of creating certainty in contracts is to avoid disputes later on. So that's as far as your question
okay, so other agreements can be verbally,
they can be
implied, it can be through practice,
yes.
But property sale has to be in writing.
That's one example.
What if you've got a verbal agreement? I sell you my house for R1 million, like you say. You hand over the R1 million, but I haven't handed over the property. Would you be able to then, I suppose then you can enforce the agreement, but you still don't have an agreement. How would that then work?
Okay, it's a very specific circumstance which is dealt with. I think it is in Section 28
Right.
of the Alienation of Land Act. In terms of Section 28, if there's an agreement which is void or invalid for the want of compliance,
Yeah, because it needs to be in writing.
yeah,
It's not
then,
in
then if
writing.
one party has performed, for example,
Yeah.
paid the R1 million over, you would have a right to get your R1 million back. But the party who hasn't transferred the property would not be obliged to transfer the
Okay.
property. Section 28 says that. Section 28(2), I think, goes further to say that once the property has been transferred already and both parties have performed, even if the sale was otherwise invalid, you can't undo it
Okay.
because the transfer has taken place. And the third aspect of Section 28 in a situation like that, you would often have sometimes parties giving possession of the house and, of course, paying the money over. So Section 28 says that that whole process has to be undone before its completion. And what happens is if you've stayed in the house for a particular period of time, on the basis that you had paid the money, you'd be entitled to collect, you'd be obliged to pay rental, and the landlord would be obliged or be entitled to collect rental.
Right.
So, and of course, it talks of the value of interest and all of that. Of course, from a Sharia point of view, that is not permissible, but that's Section 28. So that's the remedy on the Alienation of Land Act.
Okay, while we're still on houses, we sometimes get, people hire draftsmen to draw plans for them. They go to the draftsman and they say, because they see this advertisement in the newspaper,
Yes.
we will draw your plans for you. And many people don't know the difference between a draftsman, between an architect, or they just know, here's somebody who draws up plans. They
Yes.
work with the assumption that the person is an architect.
Yes.
Or not even, they just know the person can draw up plans. So they go to the person.
Yes.
The person gives the impression that he's an architect, or even if he doesn't, but the person who wants the job done assumes that it's an architect.
Yes.
But let's rather make it easy. Let's say the person pretends to be an architect and agrees that these are the plans I'm going to draw up for you. The person says, I want a 3-bedroom house, I want this, I want that. I want bay windows, I want this particular view, I want a flat roof or a high roof. The plans are then drawn up, but it's not what the person wanted. What rights does this person?
Well,
I
You're
suppose it's a
talking-
loaded question. There's a lot of things.
there's a lot of
involved, yeah.
questions, but if one unpacks it, you're talking about the employer employing a professional
Yeah.
who has, for the purpose of drawing plans, the professional holds out or represents himself to be an architect, and at the end of the work, he's not. The employer is not happy with the quality of work because they haven't complied. The professional hasn't complied with a number of instructions in the mandate. Is that the
Right.
question?
Yes.
Okay, the very important aspect is there's the Architects Professions Act. And in terms of that act, it is in fact an offense for somebody who is not an architect to hold himself out to be an architect and to charge fees. And the act in fact prohibits the person from charging a fee. So if he's not an architect and he held himself out to be an architect wrongfully so, it's an illegality,
Okay.
and he's not entitled to the fees. It's based on it's a fraudulent misrepresentation. That's the first thing. The second thing is, even if he was an architect, for example, our contract law provides that there are reciprocal obligations, and the reciprocal obligations must be fulfilled before you're entitled to your performance. So in other words, before you get paid, you must fulfill the mandate in accordance with what was instructed to you. In that instance, if the roof was supposed to be in a pitched roof or a Tuscan roof and happens to be in the drawing a plain metal sheet flat roof, which
Right.
is aesthetically unappeasing by your standards if you had instructed him, then you'd say, but I'm not prepared to pay you because you didn't do your work. So first of all, your approach would be that you're not a qualified architect, you're not entitled to the charge because you misrepresented me. But even if he was, he must fulfill his mandate properly, and then he'll be entitled to his fee. You're entitled to raise the fact that you haven't fulfilled your mandate properly, and that you obviously are not entitled to your fee accordingly.
Okay, probably an appropriate time to take a break. Viewers, we'll take a short break. We'll be back after break. Stay with us. If you have any questions After the break, feel free to call in and ask your questions to Advocate Ghulam Amir, who's here. Welcome. You're welcome to call in, and he'd be happy to answer your questions.
Metro Lifestyle Center, where you can find all brands and lifestyle products at very competitive prices. Metro Lifestyle is a one-stop shop with appliances, deco, household, textiles and many more products. Metro Lifestyle is proud of their services and assistance to every customer with staff that are trained and knowledgeable. With more than 7 decades of experience and assistance from overseas imports, Metro has the advantages of helping clients save by offering the best prices. If you're interested or seeking great lifestyle products at great prices, don't hesitate to knock on the door of Metro Lifestyle Center. Give us a call on 08611 Metro.
Protea Toyota celebrates 42 years of service to the Cape Town community. Established in 1973, Protea Toyota offers a full range of Toyota cars and light commercial vehicles. Factory-trained technicians for servicing and stock a full range of genuine Toyota parts. Protea Toyota, 189 Voortrekker Road, Bellville. Call 021 946 3324.
Are you importing or exporting products for your business? Why don't you contact Fourway for an innovative logistics solution? Sea, air, rail or road, Fourway has a solution for you.
As a mum, I only want the best for my kids. That's why I choose Excel from TIB. Excel improves cognitive functions such as alertness, learning and memory, and is completely natural. Great for kids and great for me. Excel is brain power.
Do you need to renew your car licenses or change car ownerships? Do you want to pay your traffic fines? What about number plates? Do you need to get a standard number plate? Or have you been thinking about getting your own unique, personalized number plate? We get all these jobs done at Minute Plates and License, Mayfair, Johannesburg. Come to Minute Plates and License. Don't waste your time anywhere else. We are here for you.
Assalamu alaikum again. Good evening. Welcome back. We've got our guest this evening, Mr. Ghulam Amir, advocate. We're talking about commercial law. We're talking about contracts. We're talking about agreements. We're talking about law in general. Something that often comes up these days, and because of the Trump issue, and it's probably a worldwide phenomena, but it happens in South Africa as well. We know that it happens in the labor field, in labor law, where we often have some form of discrimination. Ghulam, take the example of a private school, for example.
Yes.
Private schools may have uniforms. They say, you need to wear a particular uniform. They've got a dress code. They've got sort of haircut code, and kids can't wear beards. And now we've got a Muslim boy who goes there and he wants to wear a beard because it's sunnat for him to wear a beard. Yes. He says, or he needs to wear something on his head because he believes. Can the school stop him from doing that? Because they say these are our regulations. Yes. If either you abide by it or find another school, and it's a private school, not government school.
Yes. Even private schools.
Yeah.
Are generally, they have a portion where they subscribe to GDE principles and GDE norms.
Okay.
And whether you're a private institution or a private school or whatever, you are subject to fair administrative procedure. It's your forte. Yeah. So administrative procedure and administrative law is subject to the Constitution. It's enshrined in Section 33 of the Constitution, and there's PAJA and all of those things. So the basic principle is that a school, even if it's a private school, has to act administratively fair.
Okay, I just want to add, even if it's a school that's not, because some schools get subsidies back.
Yes.
And this would apply to, we're talking about both boys and girls. Girls want to wear scarves.
Yes.
Okay.
To prevent somebody from wearing a beard or a scarf would be would amount to religious discrimination, and that is prohibited in terms of the Constitution. Now, there was a case a while ago. I think it's Krishna versus the governing body of a particular school. And I've actually dealt with this at some stage a couple of years ago. And there, Krishna was a Hindu girl, and she had to wear a nose ring. And the school actually held disciplinary inquiries, and they said to her, you cannot have this nose ring. They took it all the way to the Equality Court, if I remember correctly, and they were successful, the Krishna family, on the basis that it was part of their Hindu custom and religion to wear the nose ring, even though the school had a rule which prohibited it.
Okay.
So, in a similar vein, if you're wearing a beard for the fashion of it and it's unkempt, and that's a different story. But if you're wearing it for the purposes of religion, or you're wearing a scarf, or you'll find some of the schools have a rule where the girls have to wear a short skirt and they're not allowed to wear the pants.
Yeah.
That's an unreasonable prohibition, and if any school does that, they will be discriminating against somebody and preventing somebody from lawfully exercising their constitutional right to practice their religion freely, and they can be then taken to task. But generally, if one addresses the school and the governing body, they are well versed with this, because it's not a new issue that arises. There's been a lot of law behind it, and generally if one interacts and exchanges with them, they generally are reasonable.
Okay, and I suppose these days most people would understand.
Yeah.
But I suppose the school can then insist, if you're going to go with a beard, at least it needs to be neat.
Yes.
They can also insist that if you're going to wear a scarf, or you're going to wear a topi or a hat or whatever,
it must conform to the uniform.
To the uniform.
Yeah.
Particular color,
Yeah.
those type of things they can.
Yeah, and I
say.
think that is something that the individual who wants to wear the beard or the pants or the scarf will have to conform to, because that's reasonable, I think.
Okay, but it's absolutely clear they can't forbid you from doing it.
Absolutely clear, they can't.
A religious discrimination.
Absolutely. You can take it to the Equality Court, and there'll be a finding against them. And the Equality Court, by the way, let me just say, for the benefit of the listeners, the Equality Court is not something that's going to cost you a substantial amount of legal resources, because you simply go there and you get the clerk of the Equality Court and the people that are there that will assist you, and you say to them, this is my problem. They write the statement down. They then issue a summons against the relevant school or whoever, where there's a discrimination. It doesn't necessarily relate to school, your employer, wherever it may be. If there's a discrimination, you go to the Equality Court. It's a service to community, really. It's a very inexpensive procedure. It's like the maintenance court, really.
Okay, and where will people be able to get those particulars? Is it easily available?
The Equality Court,
Google it?
You just Google it and you find the Equality Court, and it's generally based at the Johannesburg High Court. Okay. There's a clerk of the Equality Court there, or the Pretoria Court.
And this thing of unfair discrimination, obviously, I mean, we deal with that in labor law as well, even in the workplace. So we spoke specifically about school, and the same would happen at the workplace. They can't prohibit you from sort of abiding by what's required in your religion.
Yes.
Because that would be unfair discrimination.
No, they can't. I mean, I had a call the other day from somebody, and he was told that you cannot go to mosque for your Friday prayer.
Yeah.
Now, that's an unreasonable request or an unreasonable prohibition. Yeah. And it's, in a sense, viewed from a labor perspective, and I think you'll be able to shed more light on that, as an unfair labor practice, because but that's a different issue.
It would be unfair discrimination.
Unfair discrimination,
in terms of the employment equity.
So that can also be taken up. It can be taken up at the labor courts or the CCMA, or even at the Equality Court.
Okay.
Yeah.
Okay, so people then have options.
Yeah.
If it's a labor case, they can go to the CCMA or to the labor court. And even then, even if it's a labor issue, they can still go to the Equality Court, you're saying.
Yeah, because it's more a discrimination of race, of religion. So that's more the issue. I think the labor issue would become when there's a dismissal, or it's an unfair labor practice, or what's the other one they call it?
So, but it depends on how you couch your dispute.
Yeah, I think, but the Equality Court would be the better court to go to for that kind of relief. And it's an inexpensive thing, as I say. You just go there, and I think it's things that people must take into account, and they must take a stand for these kind of discrimination. It's a very serious thing.
Okay, Ghulam, one of the things we were discussing is about, often you get people buying things and selling things. For example, a guy sees a motorcycle being advertised, he goes and says, I want to buy your motorcycle, they agree on a price, and he, in the meantime, is selling his car because he needs the money to buy the motorcycle, and now the guy who's selling the motorcycle says, wait, hold it, this is not going to work. Does he have any rights in that case?
Well, there are a couple of situations. One of them is, for example, if a person has a deal and he's made a contract to buy a motorcycle, for example, with somebody, and you've agreed a price, say 20,000 Rand, but the fellow says, look, you've got to give me a deposit of 5,000 Rand, and I'll hold the motorcycle for you for the next few days, for a week or whatever. But you want to sell your car, as you say, and you are expecting that money to come in, but your car doesn't get sold, and of course you're unable to come up with the full purchase price for the motorcycle. And so the motorcycle seller, who now has your deposit, says, well, I'm sorry, but this is a non-refundable deposit and you've lost your money. Now, often that happens in many instances where you give a deposit and there's a non-refundable clause there. Now, even if it's in writing and there's a clause which says the deposit is non-refundable, it's classified as a penalty. Now, a penalty it's very important to make this point. A penalty is usurious in nature, and it is also prohibited by Sharia. It's a form of interest because it's something for nothing. Interest has a very wide definition in Sharia. Now, if it's a penalty, and the seller of the motorcycle who's got your deposit now doesn't want to give it back to you, you have a remedy in law. It's called the Conventional Penalties Act. So the penalty must then be fair, and he must have lost out. So if he gets another buyer for the same price, for example, then he suffered no loss, and the penalty is no good, and he's obliged in law to return that to you. Now again, one finds that there's a big impediment in relation to getting redress.
Okay.
Because one thing is knowing your right, the other is getting the redress in a court of law.
Okay, can I stop you there? Sorry to interrupt. We've got a caller on the line.
Okay.
Assalamu alaikum, good evening. You want to call? Caller?
Walaikum salam.
Ji, go ahead with your question for Ghulam.
Professor Raja.
Ji.
Okay, I've got a question. It's related to a UK scenario.
Go ahead.
Now, it has to do with an winding up of an estate, right?
Right.
Now, I've got relatives in the UK. They went to the properties actually in India, and they went to the UK and they transferred some properties in the name of some nominees. Okay, so when we try to do a check, those properties don't seem to exist anymore. Now, the people involved here is one guy who always professed to be a solicitor.
All right.
Okay, so when I did a check on him with the British legal fraternity, there's no such person that exists, right? He has no, I think it's called an SRA number or SRN number in the UK, and he cannot be traced. The other brother professed to be a medical doctor. So when I did a check with the Great Britain Medical Association, there's no such a person as well.
Okay.
So both these brothers seem to be like, I would call them like bogus lawyer and bogus doctor.
False representation, yeah?
Yeah, so Brother Ghulam Amir just mentioned earlier as fraudulent misrepresentation. Can we take this matter up as on the basis of fraudulent misrepresentation?
The people that you're talking about, was it an advertisement that you saw? How did you get in touch with them? Was it through the internet?
They're relatives of mine. They are our relatives.
Okay, so it's somebody that you know.
Yes.
Are they stationed in South Africa or are they stationed in the UK?
They're stationed in the UK.
Okay.
I think, just let me understand, sorry, the question, brother. The properties are in India.
That's correct.
And the person who transferred the property out is based in the UK and who represents himself to be a lawyer.
That's right. One professes to be a lawyer, and the other one professes to be a medical doctor.
Okay. Now, I'm aware, I haven't fully read up on this, but I'm aware there's been some serious changes in the law in India relating to the transfer of properties. And what they've done is they're trying to codify the entire property system so that it avoids this kind of fraud in the future. And the best way to deal with that is to actually appoint a qualified person in India who will be familiar with the service. And Indian law, whether it's Indian law, American law, Canadian law, Australian law, any other law, South African law, they're all based on one premise, that if property is transferred contrary to the owner's consent, then there was no intention to transfer the property. And even if it's transferred 10 owners down the line, it can be reversed and come back to the original owner, provided the original owner, who had good title to the property, is able to prove that he did not participate in the transfer of the property to the person after him. So all you've got to show is that if the property, for example, you mentioned is in the name of an estate, right?
My late grandfather.
Right. So practically, what you have to do is you have to get somebody in India who's an attorney there, and they have to go through the motions in their court, and in fact, not even their court, their deeds registry system, to show that the deceased did not transfer the property to the person after him. That's all you got to show. You don't have to show the subsequent frauds. Once you show the first fraud, in other words, that there was no transfer to the subsequent person, all the subsequent transfers become void automatically as a matter of law. And then it gets transferred back to the original estate. And from there, you will then proceed to distribute it in terms of whatever will or estate laws are applicable at the time. But it's not a difficult thing to do, because our courts, our law, generally international law, has recognized that property can only be transferred if two things happened. And in South African law, for example, and it's a universal concept, one is there must be a registration of transfer of the property. So in other words, if I own a house and it's registered in my name at the deeds office, two things have to happen for there to be a valid transfer of ownership. One is it must be transferred to the next party, the subsequent owner of it, in the deeds office, and that, is done by going to a conveyancer. You sign certain documents, he takes it to the deeds office, he stamps it, and it's transferred. But that is only half, or only one component out of two, which is required for a valid transfer to take place. The second component is, in fact, an intention to transfer. An intention to transfer. And in our law, they call it real intention, or in Afrikaans, the word is used, sakelike ooreenkoms. There has to be the underlying agreement. And that underlying agreement must exist. So if there's a fraudulent transfer, obviously, the underlying intention does not exist, which then negates the transfer. It makes the transfer void and unenforceable or illegal. And once a transfer is void or unenforceable or illegal, any court in any jurisdiction looking at that transfer will say it's void, I've heard the evidence, I'm now setting it aside. So even now, very important, if you've had a transfer to one person fraudulently, that's a simple situation. But the situation becomes slightly complicated when you've had the transfer from person A, the deceased for example, to B. Now that may have been a fraudulent transfer. But then the question you may want to ask is, what if B sold the property to C, and C paid to B the proper value? In other words, the market value. And then C, in fact, sold it to D. Now you've got four purchases down the line, and D also paid C a full market value, proper sale agreement, everything. Now the question is, what is the position that D finds himself in? Because ultimately, he is what the law considers to be an innocent purchaser, a bona fide purchaser in good faith, and he paid value for it. So the question is, why should he suffer? That's the obvious question. And normally people see, well, he paid the value, there's an agreement, there's nothing we can do about it. But that's not so. according to South African law and international law generally, because if he took property which was originally tainted by theft, there was never a valid transfer that he took. He can never take a transfer better than the one who gave it to him. And the one gave it to him had a tainted transfer. And if you go to B, his property was his title to the property was tainted by the fraud. So if the fraud carries right through to the end. So in that situation, the true owner of the property will get the property back for no value because he's the owner of it. And whatever D paid to C, he will have a claim against C. C will then have a claim against B. And that's how it goes. They got to follow the thief up the channel. I hope that answers the question.
Jazakallah.
Okay.
Okay, Jazakallah for your question, and it's time to take a break. Viewers, stay with us, and if you have any questions, call in after the break. Mr. Ghulam Amir will be happy to answer your questions. Time for a break. Thank you. Assalamu alaikum again. Good evening. Welcome back. Our guest, Advocate Ghulam Amir, ready to answer all your questions. If you have any questions, please call in. The number will be on the screen for you to see so that you can call in. There's the number. It's 011 086 7777. We were talking about fraudulently selling property, and Ghulam answered that question. But before the caller, we had Ghulam was talking to us about conventional penalties, and I interrupted him because we didn't want to keep the caller on the line much longer. Ghulam, could you please continue?
Yes.
You were talking about conventional penalties.
You will remember talking about the example of the deposit that one has given to the motorbike owner, and of course you didn't sell your car, and now you're stuck because you don't have the money to pay for the rest of the balance of the motorbike price. And the owner of the motorbike doesn't want to give you back your deposit. That falls within the Conventional Penalties Act. And the Conventional Penalties Act in a nutshell says that if there's a penalty, it must be reasonable and the court has a discretion to enforce it.
Okay, can I stop you there again?
Yes,
We've
got
another call on the line.
All right.
Assalamu alaikum, good evening. Caller?
Good evening, and how are you?
Very well. How are you? Please, your question.
Yes, my question is like this. I bought a property from someone who is deceased now, but I bought all the receipts, and we have signed some sort of a document indicating all the payments that I have actually made to him.
All right.
Now, unfortunately, he passed on. But now, the property that I bought from him, he bought it also from someone, but by then the transfer was not actually effected, meaning that the property in question was not transferred to the person that I bought the property from.
Okay.
Now, it's a tricky one. I would like to get your advice on this one, please.
Okay. Do you have any agreement in writing, or the only thing you have is the payment and the receipts?
We've got the receipt and an agreement in writing, but we drafted the agreement, the two of us.
Yes. Well, the property, as I understand your question, was owned by a third party. The third party sold it to the deceased. Is that correct?
That's correct, yes.
And the deceased then sold the property to you?
Yeah.
Okay. Now, you've got an agreement, you say, but the agreement, I presume, is between you and the deceased.
Exactly.
Now, what you will need is an agreement between the third party and the deceased. Has the deceased shown you such an agreement, or have he given you such an agreement?
I haven't seen it, but he told me that this agreement is in place.
Okay, but what is your difficulty? Who is giving you difficulty to transfer the property? Have you paid for the property in full?
No, I've paid about, say, 80% of the property.
So what is your problem currently? What is your problem?
Yeah, now, the problem is that when I approach the family of the deceased,
Yes.
you see, they tell me that I must wait, for the estate to run and be completed.
Yes.
Now, my fear is because this was not actually, I didn't actually claim anything against the deceased estate. Will I not be in maybe unfavorable situation?
All right. There are a number of issues. You've got a few hurdles, as I see it.
Yeah.
You have to claim from the estate transfer of the property, and you have to claim from the estate and pay to the estate the balance of the 20% that you owe. Now that's between you and the estate. So let's first sort that out. Once you've got the 20%, you can say to the estate, I'm giving you the 20%, transfer the property to me. Now that's, of course, if the deceased had the property transferred in his name. But it seems to me from what you tell me that the property was not transferred into the deceased's name. Am I correct?
You are correct, yes.
So the easiest thing for you to do, in fact, is to go to the third party who sold to the deceased, make contact with him, and say to him to give you the agreement in terms of which he sold to the deceased. He or she sold to the deceased. Once you have that agreement and you have his cooperation, then you will tender to pay 20% of the property value to the deceased's estate, and you will take transfer of the property directly from the third party. And you need to get someone in the legal field to assist you. It's a very simple thing to do, really. They'll do a double transfer. It's not complicated at all, number one. Number two, it is not correct that you have to wait for the estate to be wound up. The winding up of the estate really relates to the heirs and the distribution of the deceased's wealth, etc. Your transaction is not within the purview of the winding up of the estate where you have to wait until the end. Your transaction is within the course of the winding up of the estate. And there's no reason in law why you can't pay the 20% and finish your transaction at any time once an executor has been appointed, which means right now.
Yeah.
So it's a simple issue, really. You've got to talk to the third party, make sure that you get the agreement and his confirmation. Once he does so, you pay the 20% to the deceased estate, and you take transfer directly from the third party against payment of the 20%.
Okay.
Okay.
Yeah, thank you very much. Say, my last question, say, if the third party becomes negative or not cooperative, what steps should I take?
Well,
as a matter of interest.
Then you'll have to bring an action against him to disclose to you the sale agreement.
All right.
Where he sold to the deceased.
Okay.
That's what you're going to have to do. Of course, if you don't have that sale agreement, then your chances of getting the house are problematic.
Is it?
Yes. As I said to you earlier on, it's an important part of enforcing a contract to have a written agreement in place.
Yeah.
All right.
No, thank you very much for your advice.
Okay, thank you for your call. I hope it was useful. Ghulam, thank you for answering that. It's time for our final ad break. Viewers, please come back after the break, and if you have any further questions, Ghulam Amir is ready to answer your questions. Assalamu alaikum, good evening again. Our guest this evening, Mr. Ghulam Amir, an advocate who's here to answer your questions, and we've got a caller on the line already. Assalamu alaikum, good evening.
Assalamu alaikum.
Wa alaikum salam.
Can you hear me? My name is Mohammed. I just want to find out about leasing of property. Am I the right program?
Go ahead.
Okay, well, what actually happened, I'm leasing a property, right? But it's through an agent, okay?
Okay.
So the agent negotiated a deal with the tenant on my behalf, okay? the tenant will pay the full year's rental, which is quite substantial amount, okay? When we signed the lease, the tenant only paid half into the agent, but the agent never told us that the tenant paid only half. When we finished signing the lease, then the agent only told us, okay? Then from there, what happened, we negotiate and all that. At the end of the day, we went to attorneys and the tenant transferred the balance of the money into his attorney's account, right? While we were negotiating was going on, and then they used this as a strength that they got my balance of my money into their trust account. As it was going on, and then I got the eviction, I applied for eviction order, okay? The next minute I just heard that the tenant's attorney paid the money that was paid into the trust account back to the tenant. So I just want to find out if that is legal, if that can happen, or is there something wrong there?
Okay.
All right. Just let me understand the question carefully.
Yeah.
You've got a written lease with the tenant.
Yes, a written lease with all the clause and everything.
Yes, and in terms of the lease agreement,
Yes.
The rental was to have been paid
In
to
full.
your agent
In full, yes.
in full, the 1 full year's lease, rental.
Yes, that's right.
And the tenant only paid half, and subsequently he then paid the balance into his attorney's trust account.
Yes, because he said that the letting agent didn't tell us the full story. But then we negotiated and we went for arbitration, then it fell through and all that. Then eventually when the money ran out that he paid in, then I asked for the court order to have this guy removed from my property, right? But then they come up with this security to the agent, to the lawyers, and say, look, the balance of the rental is now being paid into a trust account by the tenant's attorneys. So then we found out later that the attorneys of the tenant gave the tenant the money back.
Okay. Now, to cut a long story short,
Yes,
if the attorney representing the tenant
yes,
gave you an assurance in
Yes.
writing, or your lawyer,
yes, in writing, yes.
that they are holding the money in their trust account as security to avoid eviction, for example,
Yes, thank
which is
you.
presumably what happened,
Yes,
then they're holding the money on your behalf, and they're not allowed to release it to the tenant. If they do release it, you have a claim against them for the money. You must ask the attorney for the money, not the tenant. And if you have difficulty there, you may then approach the law society and say to the law society that these were your funds that were held. Obviously, it must show in the correspondence.
yes, no, we got it, yes.
And you must go to the law society and say, this attorney held these monies on my behalf as security, and he has unlawfully released the money without my consent. Because once an attorney holds money for you as a stakeholder,
Yes.
he cannot release the money to a third party unless you authorize it.
Okay.
So either he's got to pay it back to you, or he's going to be liable personally in some other way.
Now, can I just ask you the second question, please? Now they first said we must get eviction order that went to the courts, right?
Yes.
Then, because there was damage to the property and with the furniture, a long story, we got a list of claims, TV disappeared on the property and all that. So now they said that is two separate issues, two separate summonses. Or can it be combined in one?
You can
Must two separate summonses be served?
No, you can combine it in one claim. Because
one
it's one
claim.
claim, really, yes. Of course. You'll have two different claims, but in one summons, one cost,
in
one
one-
summons. And
one cost.
yeah, and I don't know what the value of it, but if
No, we looked, the value is quite high. I don't want to,
Yes.
the rental it's an upmarket place, so the rental is
yes,
quite high.
it's a residential property.
A residential property.
Yes, I think you obviously would be advised to issue summons against the tenant for the amount in respect of the rental,
Yes,
in respect of the damages.
yes,
And while you're doing that,
yes.
you must issue a summons simultaneously against the lawyer if you're entitled to. If, of course, and I haven't seen the paperwork, so it's difficult to
like
advise.
I said, that was the strength that they were arguing, because we asked the court for eviction order, right? But what they do, they drag it out. So now this guy is in arrears now.
Yes.
He's now overstaying now over more than 3 months, okay? And then we asked for eviction order. So my attorneys here in Johannesburg asked, now why don't you combine the summons? They said, no, it doesn't work like that. First eviction order, then we put the summons for damages.
Yes. So is he still in the premises, hey?
No, he's still in the premises.
Yeah. So you're going to have to get the eviction order. That's quite right. Get the eviction order, and obviously then do your damages afterwards.
Is that the way to follow it?
Yes.
So first the eviction order,
yes,
and then the damages.
All right.
Okay. Jazakallah for your call. We've come to the end, unfortunately. Often with these programs, that's what happened. We have questions. We have a lot of questions, and I think, Ghulam, we need to call you back on this program. There's lots of unanswered questions. I had some questions about compulsive buyers, what their rights are when they get into that. So there's quite a lot. So inshallah, we'll have you back on another day. Viewers, thank you for being with us. Ghulam, Jazakallah. Khair, appreciate your being here. Viewers, tune in again next week when we'll have another edition of Legal Ease with Ashraf Esop on the line, and the week after that, inshallah, I'll be back. Assalamu alaikum wa rahmatullahi wa barakatuh.